Hi, my name is Lilliana Real, and I'm an attorney in Miami. I've been practicing 15 years, and my primary area is family law. And that encompasses divorces, child support, child custody, visitation, domestic violence, and adoptions. I'm also a Florida Supreme Court certified mediator in family cases, and I'm also involved in the Collaborative Family Law Institute. In addition, I'm a parenting coordinator and a guardian ad litem. So basically, when you're going through a divorce, you need to decide which way you're going to take your divorce. If you're going to go through the court system and go through the traditional route through hearings and a trial and have everything decided by a judge, or if you're going to try one of the other methods, which may be less acrimonious, like a mediation, which you can either go through with a mediator by yourselves without attorneys, or you can have your own attorney and your spouse can have an attorney, and you can also hire a mediator that way. Mediation is a great tool. It is a form of trying to work out a settlement. A marital settlement agreement is your end goal for that in order to avoid the litigation process. And a mediator is sort of like a referee or a creative thinker and a facilitator, where they try to come up with options for how to resolve and separate in the best way possible for both parties. That includes working on a parenting plan for if you have children, and working out your time sharing, and also doing your property settlement agreement, which is very important as well. And in that end, the mediator is a very helpful tool, because the mediator is a third party who's neutral, who has no interest in what happens with your case other than to try to get you both a good resolution and to avoid as much litigation as possible. One of the other options that's available is the Family Collaborative Law Institute, which is basically an institution where there are several attorneys, there are mediators, psychologists, and attorneys that all work together in this type of program. And what basically you do is that both you and your spouse have to agree to go through a collaborative method, and you sign collaborative agreements, and that entails hiring 2 attorneys that are part of the collaborative process, and they are part of the institute. They would then schedule meetings where everyone would sit down as a team, and there would be full financial disclosure and complete openness, totally the opposite of going to a court-driven litigation in a divorce. That being said, there are some cases where litigation is inevitable. If your spouse is hiding assets, or you believe they're hiding assets, or there are other things that are going on that need to be litigated and addressed through the courts, subpoenas have to be issued and things of that nature, then you would have to go through the first option. But if you don't have to go through that way, I would say that it's much better to try to work things out amicably to avoid the acrimony that's left after a litigious divorce. I'd like to give you an example of a collaborative divorce that was successful, and basically the husband and the wife had 2 children. They'd been married for 10 years. They had a home, marital home. They had another residence that was a vacation home. They had 2 cars. She had been a stay-at-home mom, and he had been the primary breadwinner in a successful company. And they went through that collaborative process where they sat down with both the collaborative lawyers, and they sat down with a forensic accountant. They had a psychologist as well, and they basically were able to have an agreement in a couple of months versus possibly spending a year in litigation, which that's what they would have done if they had gone through the traditional divorce process. They sat down. They had probably about 4 meetings where the forensic accountant was there. The psychologist made recommendations for counseling for the children, and parenting plans were established, and the parties were very, I wouldn't say happy, but they were very satisfied with the process at the end. There was not so much of the anger at the end of the divorce. They were able to move on with their lives, and everybody was in a much better place at the end of that situation versus people who have been through, a year of litigation with each other, where inevitably the kids find out because parents have to go to court and different things like that. So I think it's a very good option, as well as mediation. And it's less money, Even though the attorneys make less fees, they know that in the long run that their clients are going to be happier, and happier clients are going to refer them more business. So even for the attorneys, it's a win-win. They know that, maybe they'll make less on this case, but that client will refer them more cases and be a much happier client, if that word can be used in a divorce situation. One of the things that I find that I'm good at, or that I have a specialty in, is children's issues, because I have two titles, so to speak. I'm a guardian ad litem for the court, which is basically where the court appoints someone, usually an attorney or a psychologist, to go in and interview the children, see them with the parents, and go to the school, talk to the counselors, speak to the children's doctors, and just make a recommendation to the court as to what's in the best interest of the child or children as far as time sharing with parents. And that's something that happens on a regular basis, where judges would want to have an independent person come in, because one parent says this, the other parent says that, and they don't want to be the one to just make a decision without having someone go out and actually see what's going on in the homes. There's a home visit that's involved with both parties. So, that is something that I, have been doing for a while, and I believe that I'm very good at that. In addition, I also do the parenting coordination, which is basically when parents can't decide on, for example, the extracurricular activities. If there's, one parent wants the child to be in violin lessons, the other parent wants them to be in piano lessons, and maybe the child wants to play football. How do you reconcile that? You don't really want to go to court for that, whether you're pre-divorce, your divorce is pending, or you're post-divorce, which means that you've already had a final judgment of dissolution of marriage, but you still have issues about your children. You may want to hire a parenting coordinator who's also either an attorney or a psychologist or a mental health professional, and they sit with you and try to work out, what would be in the child's best interest, without involving the courts at that point, because really the courts don't want to get involved in the day-to-day activities of the parents, and whether a parenting plan is working out or whether time sharing needs to be changed. It's much better, it's less expensive, and those are issues that I'm involved in on a day-to-day basis, in addition to being an attorney and a mediator. So I have that kind of niche expertise in the children's issues. And speaking of mediation, a lot of people can come to mediation and resolve a lot of these issues without going back to court as well. And then they would just file a settlement agreement as to, changes to the parenting plan, or changes to the extracurricular activities, or, if one parent wants to relocate when the other, parent says it's okay, you don't really need to go back to court to have those issues litigated. You can go to a mediation and work out the details of how those things are going to work out, set up an amendment to your, settlement agreement that you filed in court when you initially got divorced, and then just have the court approve it. And normally, the court will approve those agreements without any problem. So there are other ways of, resolving issues, especially with the children, which are going to happen, even after you're divorced, and they don't have to be litigated. They can be resolved so that everyone is happier. I'd just like to say that basically you need to figure out what's in the best interest of your family when you're looking at getting divorced. Every family is different. As I said in the beginning, some families are going to have the acrimonious litigation because there have been too many things that have gone on, and unfortunately that has to be done that way, or somebody's hiding assets or something of that nature. But if that's not your case, then I think that for the family well-being, it's so much better to try to work out your issues amicably as much as possible. And that doesn't mean that you have to, lose out on everything or give in to the other person. You can find a middle ground. You can work out solutions that are, workable for both sides, that, where everybody seems, to be okay, or at least not as unhappy as they would if a third person were deciding their future, like a judge. So I would say that definitely, think of your options, try to look at mediation, look at what's online. There's a lot of different options right now. There's collaborative family law as well. You can go through a mediation, even before you are filing your divorce, which is also, less expensive and better for you. I think that you need to think of your family long term, especially if there are children involved. The children are going to be with you until they're at least 18, and you're going to be having to deal with the other person, the other parent, till that child's at least 18. And you have to think of those issues and how, which route you choose is going to affect that relationship and those relationships. And your children are going to thank you for choosing something that wasn't so acrimonious if you can help it. If you need any further information or would like to have some questions answered, if there's something you didn't understand, feel free to fill out an inquiry form on this website, and I will get back to you if I'm able to.